Hello friends, welcome to our channel Gurukul of Company Secretary. This channel is created for uh, CS students who are preparing for the CS Executive and CS Professional examination. And in this video, I am going to explain Section 149 of Companies Act. Myself, Praveen. Let's continue on the topic. Now you can see why this section was implemented. To enhance corporate governance by preventing excessive concentration of power and promotes impartial decision making, accountability and transparency. It provides unbiased oversight, ensuring transparency in financial and operational matters. Gender diversity by promoting women director gender diversity on boards, for protecting investors and for clarity on roles and responsibilities of directors. In this slide, let's talk about Section 149(1) of Companies Act relating to composition of Board of Directors. Whether a company can have n number of directors, there is certain restriction on minimum number of directors and maximum number of directors. Let's see minimum number of directors. A company must have minimum number of directors. For a private company, at least 2 directors should be there. In case of public company, at least 3 directors should be there. For a one-person company, as the name itself suggests, one can be a director in OPC. In case of maximum number of directors, a company can have maximum of 15 directors. To appoint more than 15 directors, a company must pass a special resolution in its general meeting. There are certain exemptions relating to central government company where a central company is wholly owned by a central government or state government. Then in case of maximum number of directors, this section is exempted for central government. Let's talk about resident director requirement. At least one director must be a resident director. Like, he must have been stayed in India for total period of not less than 182 days during the previous calendar year. In this slide, let's talk about Section 149(2) of Companies Act 2013. This is applicable for existing companies prior to commencement of Companies Act 2013. Existing companies shall comply with Section 149(1) or composition of Board of Directors within 1 year from the commencement of the Act or from the date of notification of the rules in this regard as may be applicable. Comply with such requirements of this section like Section 149(1) or composition of Board of Directors. This slide speaks about Section 149(3) of Companies Act 2013, which states about residency requirement for directors. Every company must have at least one director who has stayed in India for a total period of not less than 182 days in the previous calendar year. This ensures that the company maintains a strong connection to the Indian jurisdiction, so that the director stays in India, look after the company's management, which ensures corporate governance, uh, transparency, and accountability, as we had looked earlier in slide number 2. Let's talk about Section 149(4) of Companies Act 2013. In this section states that independent directors requirement. Independent directors are the directors who do not involve in day-to-day business of the company. Independent directors enhance corporate governance, accountability, and transferability, ensures accountability and transparency. They provide protection for investors, and it also provides clarity on roles and responsibilities of directors between executive and non-executive directors. Every listed public company must have at least one-third of total number of directors as independent directors. If there are 10 directors in a company, then at least one-third should be independent director in a listed company. Central government may prescribe the minimum number of independent directors for any other companies or class of public companies. In this slide, let's talk about Section 149(5) of Companies Act 2013, which states minimum number of independent directors for a company. The minimum number of independent directors for a listed company must have at least one-third of its total number of directors as independent directors. For unlisted public companies, it shall have at least two independent directors with respect to paid up share capital of 10 crore rupees or more, turnover of 100 crore or more, or companies having in aggregate outstanding loans, debentures and deposits exceeding 50 crores. For such companies, they shall have at least two independent directors. In this slide, let's talk about Section 149(6) of Companies Act 2013. It states definition of an independent director, which is very important. Section 149(6) specifies the criteria that a person must satisfy to qualify as an independent director in a company. The key conditions are the individual must be a person of integrity and possess relevant expertise and experience in the industry. And the individual must not be a promoter of the company or its holding subsidiary or associate company. They must also not be related to any promoters, which means they should not be a relative to any promoters. The independent director should not have pecuniary relationship with the other directors. What is pecuniary relationship? It is nothing but the pecuniary relationship means it is the relationship of independent director which refers to any financial relationship or transaction that could influence the director's independence and impartiality on their role in company's board. Thus, that is why the individual must not have any pecuniary relationship with the company, its holding, its subsidiary, or associate company during the two preceding financial year or the current financial year, except for receiving remuneration and transactions that do not exceed a prescribed threshold. He should not be a relative, or there should not be any relative who is in key roles in the company management. None of the individual's relatives should hold a key managerial position or be an employee of company for the preceding 3 years. Having a significant pecuniary relationship exceeding 2% of company's gross turnover or total income, or 50 lakh, whichever is lower. The independent director must not own more than 2% of voting power in the company. The independent director must not be an employee or a partner or executive in the company or its subsidiaries or holding or associate companies. As an auditor, legal or consulting profession in the preceding 3 financial years, the independent must not have been served as an auditor or legal or consulting professional. Additional requirements. Any other criteria as may be prescribed by central government. Section 149(7) states about declaration of independence by independent director by providing a written statement on two occasions, like before their appointment. The independent director must give a declaration that they meet the criteria of independence as specified in section 149(6), or in every financial year once appointed, that the independent director must submit this declaration at the first board meeting of each financial year, or whenever there is change in their status that affects their independence. Why section 149(7) is required? It ensures the directors remain unbiased and qualified as per the independence criteria. It builds trust and transparency in corporate governance. This provision helps maintain the integrity of the board of directors, ensuring the company is managed in fair and transparent manner. Section 149(8) of Companies Act 2013 states roles, responsibilities, and functions of independent directors in a company. The duties and responsibilities of independent directors are specified in Schedule 4 of Companies Act 2013. This schedule outlines their code of conduct to ensure effective corporate governance and accountability. What is code of conduct for independent directors? It provides guidelines for professional conduct relating to maintain integrity, objectivity, and professional ethics of independent directors. An independent director must act in best interest of the company and its stakeholders. Independent director must provide impartial judgment on board decisions. He safeguards the interests of minority shareholders. He should main, he maintains balance. He balances the conflict of interest. Duties. Independent director must attend board and committee meetings regularly. He shall evaluate company's performance and ensure legal compliance. He protects the confidentiality of company information. Manner of appointment. The appointment of independent directors must follow transparent and formal process. Code of conduct also contains performance evaluation. Independent directors' performance must be reviewed as part of the overall board evaluation. This section ensures that independent directors perform their roles effectively and align with the principles of good governance. And it also maintains a checks and balances system on the board, promoting transparency and protecting stakeholder interests. Section 149(9) of Companies Act speaks about the ways in which the independent directors can be compensated as remuneration. Key provisions regarding this are: independent directors are not entitled to ESOPs, that is, employee stock option scheme. Independent directors can be paid through sitting fees, reimbursement of expenses, that is, while participating in board or other official meetings, or through profit linked commission. If approved by shareholders, the independent directors can receive a commission from the profits of the company. Why section 149(9) is important? It ensures that independent directors remain unbiased and do not have any personal financial stake in the company's ownership. It promotes their focus on maintaining transparency and governance without being influenced by potential gains from stock options. Let's talk about section 149.10, which deals tenure of independent directors in a company. Independent director can hold office for maximum of 5 consecutive years in a company as initial term. For reappointment of an independent director after the first term, they can be reappointed for another 5 years, subject to approval by shareholders through a special resolution, disclosure of their reappointment in board's report. Total tenure of an independent director in a company is 10 years. After 10 years, there is a cooling off period. Like after completing 2 consecutive terms, they must take a break of 3 years before being eligible for reappointment as an independent director in the same company. During this cooling off period, he must not be associated with the company in any capacity, whether directly or indirectly. This section prevents over-familiarity and ensures fresh perspectives on the board. It also promotes good governance by avoiding prolonged influence of any individual independent director. Section 149.11 talks about total maximum tenure of an independent director in a company. An independent director can serve for 2 consecutive terms according to section 149.10, each term being up to 5 years. This means the maximum consecutive tenure is 10 years. After 10 years, there is a cooling off period. Like after completing 2 consecutive terms, the independent director must observe a cooling off period of 3 years. During this period, they cannot be reappointed in the same company as an independent director or with associated company in any other capacity as an employee or consultant. Purpose of section 149.11 subsection 11 is it ensures rotation and diversity of thought on the board of directors. It prevents over dependence on the same independent directors, promoting better governance and fresh perspective. Section 149 subsection 12 states that liability of independent directors under certain circumstances. Independent directors or non-executive directors are liable for only certain such acts which are directly attributed to them through decisions taken at board or committee meetings, whether they had knowledge of wrongdoing due, due to board processes or whether where they failed to act diligently in preventing such wrongdoing. Independent or non-executive directors are not personally liable for acts of the company unless proven that they were involved or consented to such acts. Diligence requirement. To avoid liability, directors must act in good faith, with reasonable care, and in alignment with their duties as specified under the Act. Why this provision is important? This provision protects independent directors or non-executive directors from undue legal risks while encouraging them to take up roles in companies. It ensures that they are held accountable only for matters within their control or knowledge. Section 149, subsection 13 states retirement of directors by rotation do not apply to independent directors. Exemption from rotation. Independent directors are not subject to retirement by rotation, which generally apply to other directors as per section 152 subsection 6. They serve for a fixed term for up to 5 years as per subsection 110 and 11 of section 149. The purpose of this exemption is to ensure that independent directors remain unaffected by rotational policies, maintaining their independence and long term contribution to the company's governance. Why Section 149, subsection 13 is important? It underscores unique role of independent directors who are appointed to provide oversight and unbiased judgment. This keeps their tenure separate from operational dynamics of rotational appointments, allowing them to focus on governance responsibilities.